Today we are talking about negotiations again, and we did this session a few weeks ago, and the video got all messed up. And I know a lot of people are viewing these videos after the fact so that they can watch things in order. So we're going to go ahead and talk about negotiations again today, which is great from my perspective because I think it's crucial. Um, Absolutely crucial, and probably one of the most important things that we can talk about. And we've got a lot of great questions that have come in that we can go over as well. So, as a little bit of a primer, my name is Billy Tarasio. I am an Arizona attorney, and I've been a practicing divorce attorney since 2005. I own Modern Law. We're a law firm here in the Phoenix area. And this seminar is part of an 11-part series all about divorce and family law in Arizona. And it's essentially designed to take you from start to finish and walk you through how to file pleadings and what to expect in the divorce litigation process. And it should help you if you're representing yourself. It should help you if you're represented by an attorney. We talk about practical things like how to set budgets, how to determine a cost-benefit analysis of how much money you should be spending on your particular case, and trying to take a really analytical approach to the practice and your case. And my hope is that by applying these sorts of very practical analytical tools, it can be a little bit of a cheat sheet when you're trying to make really emotional decisions that might seem impossible. Having this framework to fall back on should ideally make things easier. So today we're talking about divorce negotiations, and this is really important because 80 to 90% of cases settle. They may not settle right away. They may settle 6, 12, 9, 18 months down the road, but most of the time cases settle. And the better you are at negotiating, it means you will be involved in negotiations. Even in those 10% of cases that do go in front of a judge for a final decision, it doesn't mean that all of those decisions are being litigated in front of a judge, and it doesn't mean that you haven't engaged in negotiation. So it's applicable to every single case. Sorry, I'm a loud drinker. It's true, right? All right, let's start here. If any of you have watched the show Ray Donovan, it's on Showtime, and it's a very cool show. And Ray Donovan is this fixer in Los Angeles. I think it's Calabasas or whatever, which is maybe a like hotsy-totsy suburb. I don't know exactly, but he's in Los Angeles, outside of Los Angeles, and he works for a law firm that handles all of these really complicated rich people problems, like NBA players who are cheating on their wives and getting people pregnant, or when drug dealers kidnap other drug dealers, like situations where you can't necessarily call the police, you can't necessarily walk into court, but you still have a problem that needs to be solved. And really, anytime you're in any sort of litigation, whether it be family court or a different sort of litigation, you have a problem, usually between two adults. You're not on the playground, and so nobody's like pushing and shoving and punching each other in the face, and you take your problem to the judge and you follow the procedures, and this is how we resolve our disputes. Really, this is what the court system's for. Well, in Ray Donovan's world, he can't go to the court system, so it's kind of more like the playground. But what's really cool about the show is he is getting creative solutions all the time. And there's a lot that we can take away from his show, his character. There's this great scene that really stuck out to me. I think his boss was kidnapped. So Ray Donovan's boss, this owner of this law firm, was kidnapped by some gangstas that were all thugged out with like massive amounts of like gold jewelry and ripping muscles and guns and cash. Why are you shaking your head?
I just like how in depth you're going.
So, and Ray Donovan walks in and he's got his small Jewish, glasses, scared, skinny man, his boss, like freaking out next to these massive thug like guys with the guns on the table. And the first thing that Ray Donovan does is he takes the guns and he puts them away. And this is like him setting the stage for negotiations, because before you can negotiate, before you should even start negotiating, you need to make sure that you're in a place where you can hear one another and communicate. Um, and if there's a gun and a very intimidating person sitting across from you, most likely that's not going to be the case for you. But it doesn't matter. Let's say you're in a situation where there's an imbalance of power, and there's one person who, let's say, makes all of the money and makes all of the decisions. You may have an imbalance of power, and so figuring out a way to kind of get the guns out of the way, or even the table, level the playing field, um, should make it easier for the two of you to begin communicating and hopefully finding a win-win. Okay. And there's a lot of different ways that you can go about leveling the playing field, but the environment matters. So before you even start negotiating, you want to make sure that you're in a good place. If you are a morning person, and it's at the end of a day, it's 8 o'clock at night, you've been working, you've just put your kids to bed, you're exhausted, this is not a good time for you to have a discussion, a heated discussion with your ex on the phone. If you're not in a great place, and the stakes are high and it really matters, and you're talking about negotiating terms of your divorce or your separation or your child custody case, then that's something that you want to keep in mind so that you can set the environment to make it work best for you. Where is also something to think about. Should it be on the phone? Should it be in person? Should it be at your kitchen table? You get to decide here, but many times it makes sense to pick a neutral location, especially if there is an imbalance of power at all. Let's say in this particular hypothetical circumstance, husband is in the marital home. He makes the majority of the money. He makes the majority of the decisions, and he wants you to come over and sit at his kitchen table and negotiate. You may not be in a place where you feel comfortable, or you feel like the playing field is level. You're in his space, literally in his space. The same thing is sometimes true for lawyers' offices. Sometimes it's best not to meet at either lawyer's office, but instead at a neutral place. Now, with that being said, we have people in our office all the time, uh, and negotiate outcomes. But we've thought about it. Our entire environment, our entire office environment is set up to be conducive to settlement. We make sure that we've got refreshments available, and we take the time to make sure that the temperature is comfortable, and we put you in the nicest room that we can if you're not our client, because we know that we can't even begin to start making progress if you're uncomfortable. And we're going to talk more about emotions and how they impact negotiation. But if you've got attorneys, you might be using a third party mediator, and you might be going to their office. You don't, even if both of you are represented, you don't have to use your attorneys for every discussion or every negotiation. There's nothing wrong with you and your partner sitting down for coffee somewhere, meeting at a Starbucks, um, a friend's house. Let's say you have a trusted, pastor that you really like, and you want to use that person as kind of a go-between. Any place that you're comfortable. Maybe you see a counselor together. You've seen a counselor in the past that you like. Maybe that environment would be good. It's got to be someplace where everybody feels safe and everybody feels like it's as even as possible. Who should be present? Okay. Most of the time, the people that should be present are mom and dad. That's it. Not dad's new girlfriend, not mom's new husband, not your parents, which happens a lot, especially with young couples. Um, the grandparents of the baby or the parents of the clients can sometimes be really involved. But this is really about mom and dad making decisions about the children that the two of you had together. The role of the step parent or new boyfriend or girlfriend is really minimalized. And I have some personal experience. When my husband and I got married, his daughter, who's 17 today, and like, oh, I love this girl so much. Happy birthday, Kaylee. She was one, and I was marrying her dad, and I spent a lot of time with Kaylee, and I was very invested in Kaylee, and I was probably more involved in what was being worked out between Kaylee's mom and dad than I should have been, because it's just not my role. But it took me a lot of years in being a divorce attorney and seeing things on the other side to kind of understand. It's just, it doesn't really matter what you as a step parent might think. It's not in your stepchildren's best interest for you to have an opinion on these parenting issues. You can feel free to give your 2 cents to your spouse or your significant other, but ultimately this is their decision, and you should have faith that they, as the parents of the children, are the most invested and will make a good decision. And then you should defer to that decision and just get out of the way and support these two parents, because so often third parties get in the way. And when we get those third parties out of the way, parents working together who love their children can make great decisions. Extended family members are the same way. It's usually significant others or extended family members can really um, cause problems. So when we're negotiating, it's important to set those boundaries, get those third parties out of the way, um, and be clear that you are showing respect for the other parent by saying, no, this is between me and that other parent. That's the first step at showing that respect to both of those parents in those relationships. That's going to start building goodwill and make it more likely that you might be able to get to a place where the two of you can reach an agreement. You don't need an ally. I shouldn't say that. If you need an ally, if you need an ally, it should be an attorney or somebody who's offering you legal advice or information that you don't have. But you know your children, right? And you usually know your finances. If you need an advisor, that's one thing. But you don't need somebody who has I guess, a stake. You might need information. You might need support from professionals in that way in order to make great decisions about your finances or your children. Maybe you want a counselor to weigh in on the best schedule for your children. But it's different when you've got somebody on your side of the aisle who has a stake in the outcome. And I would just recommend that you avoid that as much as possible. The third party usually has an agenda, and that agenda may not be your agenda. So, um, you think that's good advice? Why do you think that?
Because I've just watched enough people come into our office with third parties, and it just makes the other client or the other party just so on edge, and I just think that it makes it that much harder for them to come to the agreement.
Yeah. I mean, it's kind of like removing the gun, right? I mean, I know it's not a gun, but when you've got the new girlfriend there, I mean, okay, wife got dumped, husband's there with new girlfriend. We have the gun situation. It's a different metaphorical version of the gun, and we need to remove it. Decide in advance of the procedure. Okay, so let's say that you and your the father of your children, you guys have decided that you're going to meet and you're going to talk about a schedule change or a major custody issue, like a medical decision or procedure or whatnot. Before you sit down at Starbucks, talk about, okay, what time are we going to meet? Who's going to be there? What time are we going to end? Which topics are we going to discuss, and which topics are off limits for this discussion? That will help everybody understand kind of the ground rules before you sit down. Usually if you're meeting with a professional mediator, the first thing that they're going to go over is the mediation process, how it works, what to expect, confidentiality, where the bathroom is, how to take a break if you need one, So you look like you want to say something. No? Okay. So know before you walk in what to expect, when you can call a timeout, when you can call it a day. You may also be there are I have a lot of different types of clients. Some clients know exactly what they want in advance and think quickly on their feet and process information quickly and in an auditory fashion. They can comprehend what the other person's saying, dissect it and make a decision quickly. And then there are other clients who really need to be able to step away, look at it, and come back the next day and make a decision. That is really hard for me as an attorney. I want to get a decision. I want to get an agreement while we've got one. But if you know that you're somebody who cannot operate that way, then decide that in advance. Let your spouse or significant other know, we're going to talk about X, Y, and Z. We're not going to talk about A, B, and C. When we're done discussing, we're going to go away and sleep on it. And the next day, we're going to, let's say, exchange information regarding that and make an agreement. So this is the type of thing that you might want to decide in advance that is procedural in nature, not the substantive issues of, are we going to make a schedule change, but how will we make, what will the process look like for how to determine to make a schedule change? I know it kind of feels like we're in the weeds, but these things matter and it will make it more likely for you to get to an agreement. Okay. Oh, and I was just talking about this, how you want to think in advance of what your positions are and how you want to make those decisions. This is a really fun section. We're going to talk about emotions and negotiation. And there's been some really great new information out. And I don't even know if, let me scroll through these slides to see if I can talk about this now because I want to. Okay, good. So, it, okay, the gold standard of negotiation used to be this book called Getting to Yes, which I think is from the 80s, but I could totally be wrong. And it was a formulaic way that you could approach negotiations to get to yes. And it was things like finding mutual purpose, listening to the other side, be willing to give and take in order to get yourself to a place that could meet as many of your similar objectives as possible. And slowly through making sacrifices, how to get to yes. The latest information, I think is better, and there are better tactics than the incremental logical finding mutual purpose, listening, that sort of thing, because most of the decisions that we're making that are high stakes are extremely emotional. They're not necessarily logical decisions. And getting to yes, that formula of negotiation is very logical and formulaic. And it discounts the fact that if you are emotionally heightened, you may not care what the logical outcome is. That's just not something that you're I don't know which side of the brain it is that's disengaged, but you're not able to engage the frontal lobe and make the logical decision because you're hyped up. There is a book that I read not long ago. Do you remember what it's called? The Hostage Negotiation book. I love this book.
Was it not called that?
Nope, was not called that. But I'll find it and put it in the comments. But it's written by this lead FBI hostage negotiator, and he talks about how that tactic, that getting to yes tactic, is not the way to get a win. And he's doing some seriously high stakes negotiation. These are hostage negotiations from the FBI. Never split the difference. Yes. Oh my gosh. If you're interested at all in this type of stuff, and I really am, read this book because if we're talking about people who have kidnapped people and they want ransom and the FBI is there, the stakes are not higher. The emotions could not be more heightened. And At least in this book. I don't know what his stats are, but at least in the book, there's a lot of stories of him figuring out a way, like Ray Donovan, to get the deal done and save the people so that, they're not dying. Why are you laughing? Yeah. So he talks about what's really important to people is that they feel understood and that you truly take the time to understand. And only once they feel understood can you find an outcome that will work. And I have seen this play out in my practice a lot of times. Sometimes you've heard divorce attorneys, probably, maybe. A lot of divorce attorneys complain about how their clients will want to spend thousands of dollars negotiating about who gets the silverware, or insert your hypothetical small issue. What we all know is it's not about the silverware. We're not really spending thousands of dollars about the silverware. There's something else that the clients are trying to articulate that they don't feel heard, either from their attorney or from the other side. And until they get that, that is really the objective that they have. And until that happens, they will not be able to move on to talking about who gets the silverware. If we take this information and we apply it, it's going to take a lot of discipline. What it means, what I'm asking you to do is really, first of all, read the book, because I'm probably doing it a terrible injustice, but talking about asking you to set aside your agenda and your emotions, which is almost impossible because we're dealing with your life, your money, your kids, your housing. Nothing is more important. Nothing is more personal. I get it. And I'm asking you to set it aside and truly set it aside, not just for the purpose of getting the deal done, but because this is the person who you had children with or built a life with. And you likely don't hate them. And if you can set this stuff aside and truly listen and make sure that you truly understand what they're saying and that they feel understood, you may be able to make some serious progress towards an outcome that will be beneficial for both of you, that will be a win-win, that's never splitting the difference, that's not settling for, okay, I have one shoe and you have one shoe, but really figuring out a way to meet everyone's objectives. And if you're choosing a mediator, this is something that I think that you should be asking, because a lot of us lawyers, we will immediately jump to analyzing your facts and the law. Well, the home equity gets split, and so you're going to have to sell the house because there's no way you can refinance it. That's what we do. But that's not always the best outcome for a particular family. Sometimes for a particular family, the house doesn't have to be refinanced. He's fine if she stays in the house and they sell it in 5 years when the kids are out of high school. And just because that's not the law or what a judge would do doesn't mean that's not the best thing for that family. Okay? So even though I'm taking you through an 11-part series and I'm telling you what the law is and how you might apply it to your circumstance, this is really about your life. And you don't need a pre-programmed outcome that is what the law says you need. You only need that if you can't agree. So if the two of you can truly understand one another, get the third parties out of the way, really, really think about what's important to you, you may be able to find a win-win, which would be, indefinitely better than taking it in front of a judge, having the house ordered, sold, and splitting everything up so everybody has one shoe. Okay, now that was a little bit of an aside. Now we're going to jump into emotions and negotiation. Anxiety is the number one emotion that is experienced by people when they are in negotiations. And when you are anxious, the outcomes that you get as a negotiator are worse. You make lower first offers, you get worse outcomes, and you exit negotiations sooner. So everything that we've talked about previously, setting the stage, getting comfortable, is really designed to reduce anxiety. And what can you do? What can you do when you're headed into a situation and the stakes are very high and you're not sure what it is that you can possibly do to get your anxiety lower because it's a big deal. Um, Music can really affect your level of anxiety. Breathing can affect your level of anxiety. Think about the time of day and the things that you're doing before you head into your negotiation. If you have the ability to control the setting, um, I mean, if it were me, I might go to yoga before heading into a very tense negotiation. Or some people will take GABA blockers or GABA that you can get over the counter, or uh, drink something like dream water to help them relax before they go into um, a tense negotiation. The thing is, your outcome will be better if you find ways to influence your emotions. Ashwagandha is another supplement that people take, right, to lower stress. And so these are all things to kind of consider. Positive emotions lead to increased creativity. So if you are able to get yourself in a place where you go into a negotiation um, from a positive standpoint, you're going to be able to hear the other person better and think about a creative solution that's not just, let's just sell the house, split the equity. Um, so all the more reason to try to increase your emotions and get them to a positive place. Now, here are some other tips that I think I took out of Never Split the Difference. Identify the emotions of others. So you can say things to your spouse or significant other like, it seems like you're really nervous about where you're going to live, or um, it appears as if you're really agitated right now. So you can identify the emotions of others, and simply by putting words to emotions, you are able to take someone from a very emotional part of their brain a little bit more to the logical place in their brain, and you can help kind of diffuse the situation and influence their emotions. Um, and understand how their emotions might be affecting their thinking and yours, and figure out how to use that to your advantage. If you're in a situation where you know that you're not going to get anywhere, then stop negotiating. Come back later. But you want to productively manage your emotions. You want to figure out a way to get in a positive space, get some good creative outcomes, control yourself so that you can listen and make sure that the other person feels understood and is truly understood. This is not just about placating them. This is about getting the best outcome. The other thing to consider here is legal versus practical leverage. We talked a little bit about, how, let's say legally you have the upper hand. Legally, you can force your spouse to sell the house because you are entitled to half of the equity in the house and you can have it now. You don't have to wait. But they are just starting their career and they can't refinance it. They might be able to refinance it in several years. This is practical leverage. It's not legal leverage. You have no legal leverage to say, I'm going to allow you to stay in the house and refinance it later. Most likely, if you go in front of a judge, they're going to say refinance the house. Get your names off of it. So practically speaking, you know that your ex is starting a new career and they expect X, Y, and Z to happen. And if you're not looking to buy another house, let's say you want to rent for a while, this is practical leverage that you can use to find a creative solution. The other thing you can do is use child support's really formulaic. You put in numbers, you get an output. One of those numbers is parenting time. I had a case not that long ago where there were twin 14-month-olds, and dad really wanted equal parenting time. And mom wasn't necessarily opposed to equal parenting time, but dad worked in a job where he had to get up at 3 o'clock in the morning. And so, oh, practically speaking, having dad have equal parenting time and get the twin girls up at 2:30 or 3 o'clock in the morning and figuring out a childcare solution just wasn't going to happen. So even though mom wasn't opposed to dad having equal parenting time, she was quite opposed to the schedule and the practical impacts of that parenting time schedule. So she agreed to use equal parenting time in the child support calculator, which is really mattered to dad. And they came up with a schedule where he would have the girls during the evenings and on the weekends when he didn't have to get up in the middle of the night. So they were able to find a practical solution and kind of manipulate the legal factors with the child support numbers. Okay. The other thing is there may be things that matter to your spouse or your significant other that don't matter to the law, but they're practically very important. Things like, you know, maybe one parent wants to take the kids to church every week on Sunday. A judge is not going to order that one parent has every Sunday so that they can take the child to church. But if that's really important, that's practical leverage. There's no legal leverage there, but you could say, yes, I will allow you to take the kids every Sunday to church, but I want the kids to stay in this school district, or that sort of thing. So we are talking a little bit about splitting the difference and negotiating a little bit of tit for tat. But sometimes if you really know what's important to somebody, you can find those opportunities. Absolutely. What to do to get some help when negotiating? Mediators can be very helpful. Lawyers can be very helpful, although it depends on the lawyer. And there are so many lawyers that are very settlement minded, that want to work with people to find the best solution for them, that are not looking to run up billable hours. And then there are lawyers that treat every case the same, plow through the process. Maybe they are hurting for business, and or maybe they believe that the best thing to do is to always litigate cases. You want to be very careful when choosing an attorney to help you negotiate, to make sure that there's this fine balance between being your advocate and getting in the way of a good outcome for you and your family. Because we're talking about family law, your family is restructuring. Your family is not going away. You're going to have to continue to deal with all of these people, including like your ex-in-laws. And so the process for getting uncoupled matters. And your attorney, you should perhaps consider choosing an attorney that really understands that and won't hurt your cause. I mean, there's other people that can help you negotiate as well. We talked about pastors, we talked about counselors. You can even use friends, trusted friends, or older family members that both of you believe in. You can negotiate in writing if that's what works best for you and your spouse. There's really no rules here. You don't have to use a formal environment. This is a super fun chart about how culture affects negotiation. And it is balancing or comparing people who are emotionally expressive versus emotionally unexpressive, and people, cultures that are confrontational versus avoiding confrontation. And the cool thing about this, oh, Caitlin's, are you putting it up for our Insta folks? I guess they could tell us. So people from Japan tend to be emotionally unexpressive and avoid confrontation. That's why in the movies you see them negotiating in very silent, stoic ways. This is how they communicate culturally. Not every single Japanese person, but in general. And this is just something to keep in mind when you are interpreting the signs or the emotions of the opposing party, the person that you're negotiating with. They may not mean the same thing you would mean by, let's say we're talking about somebody who's confrontational and very expressive, like Israelis or French people or Italians. Yeah, I'm Italian. We are emotionally expressive and we're not all that non-confrontational. So that can seem like a lot, especially if you're a Japanese person or Korean or you're from Sweden. They're like, why is she so upset? We're not upset. This is just how we talk. So it's just something to keep in mind. That is obviously on a large global scale, but you can think about your spouse or your ex and think about, okay, where might they fall individually on this axis? And how can I keep that in mind when my ex is yelling and screaming? Maybe he's not trying to be a bully. Maybe he's not actually yelling at me. Maybe this is just his communication style. And maybe I can tell myself a different story about how to interpret the emphasis. Do you know what I mean? You can tell yourself that this means they're trying to bully you or intimidate you, or you can tell yourself they're simply communicating and trying to process passionate, complex emotions. So the stories we tell ourselves matter because they help to influence our emotions, which is why thinking about this sort of stuff in advance will help you control those emotions. When to walk away. Negotiators have different ideas on this. There are some excellent negotiators who will say never, ever, ever stop negotiating. The hostage negotiator, he's never, ever going to stop negotiating because, like, you walk away from the table, there's a dead guy. Actually, I think sometimes they might come back day after day, but nevertheless, you get to decide when to walk away, when you're making progress, when you feel like enough, you're not getting anywhere. There will be no progress coming out after this. You're going to trial, or it's time to kind of readjust and come back another day. Sometimes the best negotiation works over time. Sometimes people just aren't ready to settle. And it may be that it's not that your terms need to change. It's just that the timing isn't right and you can't settle your case quite yet. And it's just going to have to sit for a little while longer. All right, so that is the end of our negotiation seminar. Let's see, we have time for some Q&A, and then our next seminar is the third Tuesday of the month, and I think it's on child custody. So we'll pick up there, and then if you've missed any, let us know, and we can get you recordings of things like how to choose a lawyer, how to come up with your budget, what are pretrial conferences, how to present your evidence to court, everything. So, Caitlin, do we have any questions?
We do, but I'm going to do a quick thing and get it so that we can see it.
Hi. Okay.
All right. So one of the questions that came in, which I think is very good for this session, is my husband and I agree on almost everything. Can we just get one attorney to represent both of us and draw up all the paperwork? We want to make it as correct as possible, but we don't want to spend any more money than we actually have.
Okay. Great question. Can a couple that agrees on everything,
they agree on
almost everything, use one attorney? Yes and no. If an attorney is acting as an attorney, they can only represent one party. If an attorney is acting as a mediator, they represent neither party, and they are simply trying to get to an agreement. So most of the time in our office, what we'll do in that situation is we will represent one party, the party whoever comes to us first, and we will represent them in the pursuit of solving the problems and getting an agreement. That's the understanding. We're clear with both parties that, you know, that's what we've been hired to do. The husband and the wife, or the mom and the dad, will both come into our office and we'll talk about whatever issues are left, whatever they agree on, whatever they don't agree on, and we'll see if we can come to an agreement. Can that help save money? Absolutely. Is it in everyone's best interest? Depends on the circumstances. Remember, if I'm hired to represent, husband, I'm going to represent the husband,
Mhm.
even in coming to an agreement. So if you,
Maybe that's a good time to
it
think about taking it home and sleeping on it if you're not the one represented.
absolutely, let's say you're not represented, you probably do want to take it home and sleep on it. Should probably take it to an independent attorney. But sometimes you don't want to do that. If you don't want to do that, you can, at least talk to your family and friends. And we want to make sure that it's fair and we're not spending more money than we need to get there. So it's a fine line, and your situation should really be analyzed. And if both people watch all of this, or they read the Decode Your Divorce book, it'll give you a ton of information, or you just look online. There's a ton of information about family law and what an outcome might be and how to analyze a particular issue. And it's not rocket science. So usually if you know what you want, there's nothing that prohibits two people from going to an attorney and having everything drafted up.
All right. Um, this one goes back to our spousal maintenance
Okay.
talk,
All right.
but I think it's a good question. I was married for 29 years. I work as a nurse and make roughly 50K. My soon-to-be ex is an exec with the company he has been with for 17 years. He has a salary of like 167, bonuses, and preferred stock. Will I get half of everything, and how much will I get in spousal maintenance?
Okay.
Because it's a time where you could use negotiations to your advantage.
For sure. Yeah, absolutely. So married 29 years?
29 years,
Okay.
50K to 167.
Yeah. So this is really tough. So, okay, she had a two-part question. Will she get half of everything? Um, Property that has been accumulated during the marriage will be divided equitably, which is almost always equally. That means if you worked and um, you're going to get a bonus for the work that you did while you were married, but you don't get the bonus until after you're separated or divorced. That is still community property. If you earned it through work you did while you were married, it'll still be divided. So the short answer is yes, you'll get half of everything if everything is the property that was accumulated during the marriage. All of the debt and all of the property is subject to an equitable division. The spousal maintenance question is much harder. In Arizona, it's a two-part analysis. First, you have to qualify. And you qualify if you can't meet your reasonable needs on your own. Um, and then there's some other reasons that you can qualify. But most often, it's because you can't meet your reasonable needs on your own. Now, if you make $50,000 a year, a lot of people do support themselves on $50,000 a year. So it really comes down to an analysis of your expenses and your lifestyle. There's a massive difference between 50 and 166 plus bonuses and stock options each year. So it's possible that you would qualify for spousal maintenance, and it's possible you wouldn't.
Right.
And I wouldn't be able to tell you how much or how long. That's a very, very fact specific question.
All right, here's another good one. My ex will not negotiate. He just wants to win and punish me, not get an agreement. How can I negotiate with someone who doesn't want to be divorced?
Yeah. That might be a timing issue, or it might be one of those 10% of the cases that you just can't settle. So if somebody refuses to negotiate, simply doesn't want to be divorced, wants to punish you and use all of their resources that they can't punish you, there may not be a lot you can do. At that point, we start thinking about litigation tactics that might level the playing field. So if somebody like this person, and did she say it was a man? My husband, yeah. So if this man has no incentive to settle because he just wants to stay married, then one of the things that I'm thinking about is, okay, how do we make this a little less uncomfortable? How do I help my client get in a better position to facilitate settlement so that she's not being strung along and punished if that's what he's seeking to do over the next 9 months? So it's gonna take a very specific conversation to figure out what our options are. But it can be really hard. And it could also be a question of timing. If you've left, your husband didn't see it coming, he's blindsided, you've thought about this maybe for years, and you've thought about what you want it to look like. You're ready, you're emotionally ready, you've practically thought it out, you've got your plans. If they haven't had the same opportunity to kind of process that information, they simply may not be ready to settle, and you may need to be patient.
Would you like to do one more question?
Sure.
Sure.
If there's another question, let's do it.
All right. I want to mediate, but my wife will not go. She says her lawyer is telling her not to go to mediation yet, but we have things that we need to be discussed. Spring break is coming up, and we need to talk about camps and changing the regular schedule. I can't wait.
Okay. So this person is in the middle of a divorce, it sounds like.
Sounds like.
Spring break's coming up. He wants to make decisions about what to do for the kids for camps.
Because the schedule obviously is going to be the same because they're not going to be in school. So.
Right. And they don't want to go to mediation. Okay. Well, you can negotiate without going to mediation. And we spent a lot of time kind of talking about that earlier. This is not something you necessarily need your lawyers for. It's not necessarily something you need a mediator for. Spring break's coming for both of you. There's no way to avoid that. So maybe a phone call, maybe a letter. Really think about your circumstances and what the best place is going to be to have this conversation. He also said that she won't go to mediation yet. There are a lot of attorneys who want to wait until all of the disclosures are done, all of the appraisals have been secured on properties, you have Kelly Blue Book values on the car, before you go to mediation. I'm not one of those attorneys. I think anything you can take off the table and anything you can negotiate through a Rule 69 agreement, any agreements that you can get on the temporary issues, even like spring break, issues are a great thing. And so I would really almost never tell my client to wait. For instance, if we didn't have appraisals, I might be able to enter into an agreement that says that the equity in the home would be split per the appraisal. That my client, let's say, would refinance the property and buy out husband's interest per the appraised value, and then you just wait on that appraised value. And if you weren't comfortable with that, you could even add something like, as long as it's between X and Y or whatever. So there are ways that I think you can negotiate even in advance of getting all of the information, but that's a personal preference that not all attorneys share. I hope that answers this question.
So maybe I missed it.
Okay.
But for people who aren't in the legal industry all the time, can you refresh me on Rule 69?
Sure, yeah. So we talked a lot about Rule 69. It comes up a lot because a Rule 69 agreement is simply any partial agreement on any issue while you're in a family court case.
So you don't have to agree on everything, but if you do have an agreement on
anything,
one thing, you could do a Rule 69.
Right.
Tell the court that's not an issue.
Yes. And so what happens is, if you enter into a Rule 69 agreement, a binding agreement on legal decision making, it's off the table. You never have to go back to it. Although you can enter into a temporary Rule 69 agreement, which is on a temporary basis, I will pay X amount in child support. That is binding. You really can't get rid of it. It's very hard to get rid of. You have to prove, duress and unconscionability, and if you've entered into a temporary agreement, a Rule 69 agreement, it will be binding. And if it's a permanent agreement, like a property division agreement, there's no going back on it. And you'll never have to litigate it, and you'll never have to come back to it.
All right, sorry.
Yeah, no, I'm glad you reminded me of that. Anything else for today, or are we good to go?
We're good to go.
All right, great. Well, then we will see you all back on the third Tuesday of the month, where we talk about custody. Thanks so much. Oh, as always, if you have questions, send them to me, send them to Caitlin, put them in the comments, whatever you want to do. You can text us at 480-649-2905 or email or send them on Facebook Messenger. We'll talk to you soon.